Okay, calling case C 343540, State of Nevada versus Yuxia Zhang, and 343540, State of Nevada versus Kimball Austin Sachs. Appearances, please, counsel.
Do you know Rinetti for the state?
Charles Goodwin, 14879 for Mr. Sachs.
Shetler, 4747 for Ms. Zhang.
And we have Ms. Zhang and Mr. Sachs are both present via Zoom. This is the state's notice of motion and motion to continue trial and state's motion for discovery. There was no opposition per se that was filed by either of the defendants. However, there was an affidavit that was filed, a 43-page affidavit with multiple pages of additional articles and exhibits that were attached, that was filed by Mr. Sachs. Mr. Sachs is currently represented, and he again filed it as attorney in fact Sachs, which I have explained to him on numerous occasions that he cannot call himself an attorney in fact when he is not a licensed attorney. He did not file his affidavit in Ms. Zhang's case. He did file it in his case. However, EDCR 7.40 says when a party has appeared by counsel, the party cannot thereafter appear on the party's own behalf in this case without the consent of the court. By filing an affidavit, and I need Mr. Sachs, if you are currently typing on the computer and have your volume turned on, I need to put yourself on mute because I can hear it in the background. To the extent that the affidavit was filed, it's not an appropriate opposition, obviously, it's not an opposition. However, there were things that were stated in it that in substance appeared to be an opposition to the state's motion and would be inappropriate for Mr. Sachs to file since he is currently represented by Mr. Goodwin and did not obtain consent of the court to file that affidavit on his own behalf. So I would like to address that issue first before we even deal with the issues as it pertains to the motion to continue the trial.
May I address that?
You may.
So, Your Honor, the affidavit,
Your Honor, the defendant is holding up the sign.
what he's saying is while the interpreter is speaking, he cannot hear what the court is saying. I would guess that's because of how the volume looks at that. Austin, do you have another? Well, no, I guess that wouldn't fix the problem because of the interpreter.
Well, we don't need an interpreter. This is a real problem here because I basically heard nothing what the judge said. I heard nothing.
Okay, well then I will repeat myself so that you can hear it.
And you just need to summarize this briefly.
You can summarize, that's fine.
Austin, we're going to be speaking on the affidavit.
We don't need an interpreter.
CC, is that correct?
你需要翻译吗？
要，谢谢。
不需要。He says no need.
Okay, I'll just stand back there.
I'm just going to summarize real quick. It's concerning the affidavit. Two things that the court would like to remind you of is that you should not be showing up with attorney in fact unless you're licensed as an attorney. And number two is the affidavit should not have been filed without leaving the court. And that it looked styled as an opposition. If I could just address that briefly, and then Mr. Sachs, I think you would agree with what I say here. Mr. Sachs did reach out to me after he had received notice of the motion to continue, and he wanted to file the opposition. I had a couple of deadlines and did not respond promptly to the emails that were coming in concerning that opposition, as my intention was to oppose that opposition.
You mean oppose the motion?
Excuse me, oppose the continuance and the motion,
Okay.
and then address the motion orally. That was what my intent was. So I think that Mr. Sachs, in abundance of caution, wanted to make sure that his position on that was going to be put in there. And those were several of the things that were going to be touched in on the opposition. As far as it being an opposition to the continuance, It is not styled as one, and I don't think it can be seen as that one. But that was what the purpose of that affidavit was to get those things placed on there that he did wish to speak on in that opposition, due to the fact that I was working on a couple of different things and I did not make clear to him totally that I was going to be opposing orally.
Okay. In the future, then when he filed it, it should have been either something, either as an attachment, and you could have done, defense hereby opposes, C, attached exhibit A for the reasons why. I mean, it can be that simple, but for him to file without your quote unquote blessing, if you will, is a violation of the rules. So I will leave it at that. And I think that, that has been adequately stated. Let's get to the crux of the motion. And I think what needs to be brought about is two things. One is that originally, one of the reasons why we continued the trial last August was so that Mr. Sachs could get an expert to speak on this issue. So I would simply say what's good for the goose is good for the gander as far as a continuation. And while I agree that the state may have been placed on notice that this was a potential theory of the case, just because somebody is placed on notice, until such time as they actually get an expert report, there's no duty of the state to go out and investigate his theories of the case. That's his affirmative defense to prove that it was as a result of this gad millennium. They still have to prove the child abuse, neglect, and endangerment, but it's his obligation to come forward. They don't have a duty to do his investigation for him. And to the extent that there is a expert report that is being proffered, they have a right to get a rebuttal report. And just because that's somebody's theory of the case, until such time as an expert report is actually tendered, they have no idea what somebody is going to say. And I think what might be confusing to your client, respectfully, Mr. Goodwin, is simply because the state has doctors. It's a hallmark issue. Those doctors can't necessarily testify to the gad millennium issue. So it's not like they're going to be able to put these doctors on and your client or yourself is going to be able to ask them whether or not they're, I mean, certainly you can ask them whether or not they are knowledgeable of this issue with gadavist, I believe, or gadvium and gad millennium. Certainly can ask them if they're not, but if they're not, they can't testify to it. And the articles that he's putting forward, until I have somebody that comes forward from the scientific community that says, yes, these are true, or those are authenticated, you and I both know those are hearsay. So they're not coming in on that respect. So until such time as an adequate expert has actually been tendered with an expert report, the state doesn't have an obligation to come up with a rebuttal witness. So I think in that vein, now that we have an expert, they have a right. This is not something that's common. They have a right to get a rebuttal expert to that, and they need to be afforded the same amount of time. But we're not going to continue it for an ungodly amount of time. We're going to continue it and limit it so that your client's rights are protected, because I understand that he does need to get to trial. But for him to, in his affidavit, to state that all of these continuances are the result of the state is not true. So that's my spiel. I will certainly hear argument from both sides, but my original inclination on this would be to grant the motion to continue the trial, but limited to whatever time the state puts on right now. And we're going to reset the trial now to whatever amount of time that the state feels. And then Obviously, if you got the rebuttal expert report and you wanted your expert to be able to review it and see whether or not they wanted to do any supplementation, that would be appropriate as well. So that was going to be my inclination today, but I'm certainly happy to hear from both sides. It's your motion, so if you have anything to add, Ms. Rinetti.
And I appreciate, and the court has kind of echoed my concerns. The one thing I will say is, I did put in my motion that based upon, there's two motions, a motion to continue, motion to discovery. And the motion to discovery is really important for me in the sense of I need to gather those scientific studies that the experts relying upon, because based upon my conversations I've had thus far with individuals in regards to this issue, I do believe I'll be filing a motion regarding whether or not this expert can actually testify regarding the scientific information that's the basis of his opinion. But at the first blush, I need to at least get those scientific articles that he's relying upon before I can file a motion for maybe an evidentiary hearing. I understand we don't do the Dahlberg standard, it's something a little lower here in Nevada. However, I think there's, based upon my preliminary information that I've received, that motion will be forthcoming.
Well, and the other thing too is we also have case law that says that experts are allowed to rely on hearsay documents as long as it's the type of information that experts would generally rely upon. And so to the extent that you were to get a rebuttal expert and be able to provide whatever this expert reviewed to your rebuttal expert, you might not need to file that motion if your rebuttal expert says, oh yeah, I've reviewed these reports, and do you see what I'm saying? It might be something that you can just rebut as opposed to having to file a motion, but we're not there yet.
Not there yet. I will say preliminarily, I'm getting information that some of the science behind what this doctor is relying upon is not necessarily reliable. And so that's what I'm in the preliminary investigation regarding that.
Okay. Mr. Goodwin.
First, Your Honor, as the continuance, I just want to say a couple of things. I understand the court's position, but defense would not be opposed to granting the state some additional time to find that rebuttal witness so the trial can actually go forward, if that's what the concern is in terms of that prejudice. As Mr. Sachs has laid out a little bit in his affidavit, there is now a little bit of more of a serious hardship occurring to himself and his wife. Specifically, she cannot leave the country as the court's obviously in receipt of her passport, and she has not seen her family or anything like that for a long time. It has been a significant amount of time to be away, and she has not been able to make that. And I'm sorry, I don't mean to speak on that, but apologize, speak on that for your client, but for Mr. Sachs himself, he has been unable to find an appointment. He's got mortgages and other things that are coming out that he was really hoping to wrap the case, have it done so that he can go and see what's going to happen and move on with whatever's going on. So I think that there would be prejudice to the defense. And I think that giving leave to the state some time to find that expert and file it and not oppose that would alleviate that prejudice that they're facing specifically there. Because I do understand what the court is saying about doing a rebuttal report or a supplementation report. The reality is, though, Your Honor, that this is an appointed case. I don't know if we'll get approval for rebuttal reports and things of that nature based on that. So I don't know if I would be exploring that option, as we've just kind of barely gotten approval for this specific expert on this specific case. So there would be that prejudice there, Your Honor, and we would be opposing to it. Additionally, Your Honor, I think that as far as this case goes, we are kind of coming across to a very lengthy period of time. If any continuance is done, we would request a very short setting for a reset on this, because we do need to get this going, but we would be opposing that continuance.
Mr. Shetler, do you have anything to add?
Your Honor, I know that, and Mr. Governor addressed this. The concern is, and I did speak with Ms. Rinetti about my client traveling to see her family in China. There were some conditions put on that might be better addressed to you, Your Honor, and that's the primary concern by the delay. The paperwork that was filed speaks for itself, and you've covered the other issues, which is, I'm not going to repeat those. So that's our big problem. Is A, we need to get justice, and B, it's very challenging for my client right now because she can't travel to see family members, some of whom are ill.
And so, and I know this court, and I don't want to push my luck. I'm in the, obviously, if the court mentioned, this is not like a common thing that we see in criminal court. And so although I can set the trial now, I would like to at least be able to find the expert and then have their schedule. So I'm not asking for another continuance. The court that we give today doesn't work with that expert schedule. I'm in the process. I just need a little bit more time. I have to go through many different channels in order to find someone who can testify. There's no one here locally, so I'm finding someone. But that's my only concern. We just want to make sure that we can have that trial date, that we can make sure everyone.
So let me ask this question. How long do you need to find an expert?
If I could have like 3 to 4 weeks, and then in addition, I need to get that discovery from the defense's expert, and that may speed things up if I can get that discovery so that I can get that over to the experts as well, and file whatever motions I need to, because I think that will also require a hearing well before the trial date to flush out whether or not certain experts and certain theories can be proffered during this trial.
I don't think you need 3 weeks to find an expert. I'm not saying that I expect you to have an expert report ready in 3 to 4 weeks. I think you can find an expert a little bit faster than that. Obviously, you've already started looking and made some inroads. So my inclination would be, let's see here. We're currently at the 5th.
Remember, this may help or it may not.
Sure.
Ms. Rinetti and I had spoke, I didn't get a chance to speak about the co-counsel about possibly scheduling an evidentiary hearing on that in case we run into expert availability issues with a trial date. Probably premature, but something to at least keep in mind possibly.
And I'm sorry, what are we talking about evidentiary hearing for?
Potentially a motion to strike your expert.
I will-
My thought being, we could maybe clear up a complicated medical issue that might be able to have something tight to give to the jury one way or the other. That could be completely incorrect, but it was something that had come up.
And Jordan, I haven't spoken to the discovery motion. I was only speaking to the continuance. I still had things on the discovery motion.
Okay. Let's talk about the discovery motion then. Go ahead, Mr. Goodwin.
Your Honor, some of my concerns with the discovery motion was a very broad ask of materials that have been requested in that discovery motion. My understanding from this is that what was provided to the doctor was the doctor reports that were disclosed on the evidence,
Okay.
and Mr. Sachs, a conversation with Mr. Sachs. Now, the reports, the studies that are reported on, I'm not sure if it's defense's job to compile everything that this doctor used to gain knowledge about these situations. I'm not sure that that's something that is even something manageable in terms of discovery and whether or not I can provide that type of discovery. He has a very specialized set of knowledge. He spent years owning his craft and doing all these other types of things. And now to say, okay, well, we need everything to be relied on to make that determination in terms of studies, that's a huge ask, and that's an overwhelming ask, in my opinion. If they can find an expert who can speak on it, they'd be familiar, they should be familiar in those areas, or at least know exactly what he's talking about to say, oh, no, that's not true, or that is true. So that's a big ask. And my other concern is, and looking at this issue, is if we're talking about the things that he relied on, well, parts of those are statements from my client. And I don't believe they're entitled to that. They were never reduced to writing. The report is what was reduced to writing, and that has been turned over. So I don't think that we can compel my client to be giving that. And I don't think that we should be asked to create discovery for the state. I don't think that's what our obligation is in any way or our requirement. So in terms of what's being asked for, it's mainly what they're looking for is for us to go back and speak to that expert, say, hey, where's all your knowledge about all of this come from? And then provide that. And again, I think that what we're doing there is compiling and creating discovery in this case, rather than have discovery that would be turned over. So I don't think it's an appropriate motion at this time. Just like if we had a firearms specialist, what would be asked for in terms of reciprocal was, what reports did you rely on? What are your certifications? And we provided all the certifications and we provided the report. So I don't know, I'm not entirely sure what exactly in there would be required, because the things that he relied on to make his report were that doctor's report and conversation with Mr. Sachs.
Okay, I'm going to, because, and I'm sure your client later on is going to say, you need to challenge her on this point, and that's fine. However, criminal rules are not as up to speed as the civil rules. So let's talk about what's required for experts under the civil rules. And I'm gonna make an analogy to those civil rules as to what I think needs to be disclosed, because I agree with you in part that his statements to this expert, especially if the statements are as a result of things that can be found in the medical records themselves, are likely not discoverable. However, if you look at Rule 16, Nevada Rule of Civil Procedure, Rule 16.1, 16.1, and it's A2, disclosure of expert testimony, and specifically under B. And it says the report must contain a complete statement of all opinions the witness will express and the basis and reasons for them. 2, the facts or data considered by the witness informing those opinions, any exhibits that will be used to summarize or support them, the witness's qualifications, including a list of all publications authored in the previous 10 years, these other ones, a list of other cases, and then a statement of the compensation. I don't think that those are necessarily what I'm talking about. Is 2 and 3. So the facts or data considered by the witness informing his opinion, and any exhibits that will be used to summarize or support them. If those are contained in his expert report as to what he utilized, I would agree with you that then the state can look those up. Their expert can look those up. But if those opinions, if it's just his opinion without the basis of that expert testimony and without the exhibits that are going to be used to summarize or support them, then he needs to provide those. The expert needs to provide those. And that's what's going to be my holding on that.
Mr. John. So, and I'm sorry, I just want to get some clarification.
Sure.
To make sure that I don't do any civil, and we'll see what's
Fine.
going on here. So. I'm looking at 16.1 now, and you were saying which ones should I be?
16.1 A, little a.
Uh-huh.
So 16.1 little a, 2 B, I, and I.
We have a brief court's indulgence.
Sure.
And Judge, I would also include State v. Judicial District Court. It's a 2012 case. I can give you the site if you'd like it. And it talks about, in the context of an expert opinion, testimony, or jurisprudence recognizes the need for disclosure of facts, data, or other information upon which an expert opinion is based to facilitate meaningful cross-examination.
And also under Hallmark v. Eldridge, you have to look at, they have to meet certain qualifications. And those qualifications include that their opinion is subject to peer review or has been tested. So to the extent that he's relying on reports, if his reports have not been subject to peer review or have not been tested, that would be a factor of going against him and his ability to be able to testify under Hallmark v. Eldridge. So
I understand, Joe, and I think that according to what my understanding is, I think that all of those, the exhibits that we use to be summarized or support them, we have not discussed him bringing any exhibits or showing those to explain how this works. So he wasn't intending to introduce any exhibits.
okay.
And then as far as.
But the facts or data considered by the witness informing his opinion.
Right, so that would mainly be the medical report from YL while he was in the hospital, as well as statements from my client, so.
Okay, to the extent that there is anything else, because it's my understanding from reading your client's affidavit that he has all of these articles that were provided to the doctor. If the doctor is utilizing those articles to support his opinions, the full panoply of those articles, and not just portions of them, we're not talking about, the Cliff Notes versions, but all of that needs to be provided to the state.
I will reach out to the expert then in that's the case, Your Honor. Just because he provided them does not mean that the expert relied on them. So I will speak with him about that. I understand. I understand that, Your Honor.
I do believe throughout his expert report, he talks about studies, and in particular, he talks about something out of Ontario, Canada that he was relying upon.
Okay.
Those are
So,
just the kind of-
so that's what I'm saying.
Yes.
So anything that's contained within his report that is not attached to his report and doesn't have the name of what it is for the state to be able to find it on their own needs to be provided to the state. So if it says, this is a quote out of Black's Law Dictionary, or if it was a Westlaw citation to a case, you would give that Westlaw citation so that the court or yourself or the state would adequately be able to look it up to see whether or not it stood for the proposition that it is being utilized for. It's the same thing here. So if there is a citation to something that he is using that doesn't have a full citation that would enable either the court or the state or even yourself to be able to look up that document to make sure that it actually is what it purports to be, then that needs to be provided.
Sure.
Okay,
Essentially 16.1 compliant.
yeah. Mr. Shetler understands because he does civil. All right, I think I'm gonna give you guys until February, the state rather. February, the end of the day, February the 28th, to at least provide and get the name of an expert. And then we're gonna come back that following Monday, March the 3rd, to make sure that we are on track and reset the trial date.
And Your Honor, may I just make a brief record too, just on the
course.
discovery really quickly. I'm sorry. I understand the court's ruling. I'm not trying to argue any further.
You are fine.
To the extent that the NRCP is being used as a standard for the expert, I would just object.
And that's fine. To the extent that there is not a lot of other guidance as to what we need to use for the expert other than Hallmark v. Eldridge, which I would say that under Hallmark, as I said, one of the factors to be looked at is whether or not the information that is being provided is subject to peer review and has been tested. In order to be able to have your expert not stricken, they have to meet all of the qualifications under Hallmark. So therefore, I think it is equally as provident under Hallmark to be able to make the ruling that I'm making. I'm just thinking it's easier to refer because there's an actual rule under 16.1 without having to be vague and ambiguous as to what Hallmark requires.
Thank you, Your Honor.
You're welcome. So March 3rd, let's come back. We are gonna vacate the trial. Right now, we will come back on March the 3rd to continue the trial date. At that March the 3rd hearing, what I am going to want from the state is how long their expert, so i.e. at that point, you should have talked to your expert and found out how long your expert is going to need in order to prepare a report. The defense will have turned over anything that the court has ordered as a result of today's hearing to the state by that point, so that the expert has the ability to make that time frame analysis. And then I want both sides to come prepared with their calendars to reset this. I'm not going to go that far out. I may give the rebuttal expert 30 days to do a report. So we're going to be looking at sometime, I would say early part of May, early middle May.
And we have a copy of the court stacks.
If they want to email me, I can email you guys all this stuff after court availability is.
Okay. So, but have your calendars ready for May and June. Because I will set something for sometime in that time frame.
And have some expert availability for those types
Correct.
as well.
Exactly. Okay. Anything else that I can at this juncture?
I need to make a record, Judge.
You are not allowed to speak, sir. You are represented by counsel. So if you would like me to leave the room, I'm happy to leave the room. You can talk with your counsel and then your counsel can make a record on your behalf. So I will do that now. Mr. Goodwin, you can go call your client off the record. Mr. Goodwin, you can go call your client and see what he would like to say, and then you can make the representations going
Thank you, Your Honor.
off the record. Okay, back on the record in C 343540 and 343540 1 and 2. Zhang and Sachs. And Mr. Goodwin, have you had an opportunity to speak with your client?
Yeah, Your Honor, and there are four things Mr. Sachs would like to.
Okay,
First was touched on a little bit, but he wanted to emphasize this, that he believes that his inability to work and the financial hardship caused by this trial is now bordering on cruel and unusual with the time that it is coming along. So he would like to make that known and the record that he believes that he's crossing into the cruel and unusual punishment due to the length of time the case is doing in his own personal financial situation.
okay, I will address that. We'll address them one by one. As I said at the very beginning, to the extent that he asked for the continuance in order to be able to obtain this expert, and the trial was supposed to go back in August. It's now January, so August, September, October, November, December, that's 5 months that he was afforded the ability to be able to get his expert. The state should receive the ability as well to obtain a rebuttal expert. So to the extent that he in part caused the issues that he is now complaining of, the court disagrees. Okay, point number 2.
Understood, Your Honor. Number 2 was just he would like the court to be on notice of potential civil rights violations and pending litigation pursuant to those.
Okay.
Number 3, Your Honor,
And I don't know what you mean by civil rights violations, if you're talking about anything that the court has done. This is, as you know, anything that arises out of a judicial decision that's made by the court is not subject to a civil rights action, so.
understood.
Okay.
Number 3, he would like to correct one more issue. He did not, in his affidavit, attempt to blame the state for the multiple continuances. He stated that was a misreading of his. He did not say that the state was the reason for the continuances. And I know from speaking with him personally that I think he realizes that he was the one who requested
Okay,
the multitude of continuances.
okay,
Number 4, Your Honor, I spoke with Mr. Sachs about this yesterday, and this is why I did not personally bring it up. He's concerned about the motion to continue not being compliant with the rules of criminal procedure in terms of what was attached being an affidavit instead of declaration. I
RS
told him,
53.045 allows an declaration to serve as the same place as an affidavit would.
and I also told him, Your Honor, it could also be corrected by her simply swearing in to, and a motion's not even necessarily required for a continuance if they're sworn in and good cause is found.
Right.
So I think you still hit that, but he did like to point that out that it wasn't compliant.
And I disagree. Again, NRS 53.045 allows a declaration to be used in lieu of anywhere where an affidavit would be required.
Understood, Your Honor.
I did want to bring up, and I don't know if you all want to deal with it orally to the extent that it was hit on a little bit, of the ability for Ms. Zhang to travel. Is that something that has been addressed by both sides? Is it something that we need a ruling on? Has there been a resolution? Where are we at?
Ms. Rinetti, thank you, Your Honor. Ms. Rinetti had stated that she would not oppose travel as long as Ms. Zhang was able to sign affirmatively make 2
Swear under
statements.
oath.
And when I spoke to my client, excuse me, it gets confusing. There was some confusion on that part, and I don't know, I understand where Ms. Renetti's coming from on that. It might be better in writing, it might.
We might come to an agreement if we can. And
Okay. If there's an agreement, then I will abide by whatever the parties agree to on that issue. So if you want to submit a stipulation in order on that issue, I will abide by that. I will say that in other cases where I've been pending trial on with somebody, it was simply, you need to check in before you leave, you need to check in when you get back, and something needs to, and you need to provide, the date and times of your travel and when you're leaving and when you're coming back, so that if they don't come back at that point, I believe that, where would she be traveling to? Would it be China or?
In China,
Okay.
I'm not sure which province, Your Honor, I'll find out, and certainly that's nothing, that won't be, I'll talk to Ms. Rinetti. So far, it's just been some details.
I believe for extraditable in China, but I'm not sure. No, No? Okay,
So that's one that,
that's a little bit of an issue.
yeah, so we're trying to work around. a
Okay.
couple things, and there were some things about requiring something to be under oath for, issues, and then there's one other issue we can
Right.
talk about it if it
Okay.
becomes, there's just two stipulations I wanted.
If you all need to bring a motion in regards to that to my attention, I'm happy to do that on an OST if it needs to be done. Certainly I would want good cause. I understand that people want to see their families. I get that. But, if there's very specific, if there's, a family member that's ill or something of that nature, that obviously has more pressing need than simply, I haven't seen my family in 5 years.
I understand.
So,
Thank
All
you
right,
for that.
thank you very much. Is that all?
The status check is gonna be set for March 3rd at 9:30.
9:30.
All right.
Thank you.
Anything else for purposes of today?
Okay.
All right, thank you very much. We're off the record.